Good afternoon, everybody. Thank you for coming. For those of you who don't know me, I'm Spencer Waller. I'm a member of the law faculty here at the law school, and I'm the director of our Institute for Consumer Antitrust Studies, which is sponsoring this event. And before I introduce our distinguished speaker, I just wanted to say a few words about the Institute. We were founded in 1994 with a Cypre grant that came from a case called Glass Containers, which several of you may have been involved in. And Judge Hubert Will was the presiding judge in the Northern District of Illinois who was looking for a vehicle to fund an institute that would research, write, and speak on behalf of consumers, the tangible interests of consumers, and help to promote a more consumer-friendly, competitive economy. And that's our mission, and since that time, I joined our faculty in 2000. Jane Locke, Nina Appel, Mike Kaufman, and others were instrumental in the founding of the Institute, and Jane directed the Institute in its early years. I joined the faculty here in 2000 after teaching at another law school, and over the now close to 20 years, the Institute has been involved with programs, a student fellowship, of which 9 of the current student fellows and a number of the alumni fellows are here today, which is nice to see. We do a wide variety of events for law students. The Institute supervises the consumer law and antitrust law curriculum at the law school, which is both broad and deep. And we put on events such as this, our annual colloquium in the spring. And for the students in the room, our next event will be November 2nd, when we sponsor an antitrust career night called Why Antitrust with the ABA Antitrust section. You'll be seeing a lot more publicity about that, but I wanted you to know. So if you're not a student and you're interested in being on our mailing list or joining our Facebook page or all the other electronic things that we have, please come see me after the talk, and we're happy to add you to our database so you can be part of our family going forward. So it is a great pleasure to have Tom Rosch be here at the law school today. As most of you know, he is a member of the Federal Trade Commission appointed as a commissioner by President Bush in 2006 and will serve in that capacity through roughly the middle of next year. And before joining the FTC, he was at the San Francisco office of Latham and Watkins, where at various points he was the managing partner of that office. He's one of the most distinguished practitioners in the field of antitrust, but he has extensive experience on both the consumer protection side and has been both a public servant and a private practitioner of great distinction. He had served in the 70s as the director of the Bureau of Consumer Protection at the Federal Trade Commission. He has previously served as the chair of the ABA Antitrust section, as well as chairing the State Bar of California's Antitrust section. And since joining the commission, Commissioner Rosch has been outspoken on such key issues as the role of Section 5 of the Federal Trade Commission Act in antitrust cases, the administrative procedures used by the commission in administrative litigation, competition in high-tech and online sectors, and today his subject is one that has been in the news this week and frequently in the past, which is on do not track privacy in the internet age. So we welcome Commissioner Rosch. We're delighted that he's here. We're delighted that he's made some time for Q&A at the end. This is an on-the-record session. I understand there's one or more members of the press who are here, and questions from them and anyone else are fine. But when we get to the Q&A, we need you to use the microphone, which 2 of the student fellows will bring to you, and we would ask you that you speak into the microphone so that we can hear you both around the room and on the video, and that you identify yourself so we know who's asking what. With that, Commissioner Rosch, thank you so much for being with us today.
Well, thank you tremendously, Spencer. I appreciate this. You know, somehow or other, I think I left my notes here. It doesn't matter. It is great to be back in Chicago. not the least of which is because I get to see some old friends and some new friends. It is a place where I tried a case once before a jury here. And it was a wonderful experience. There's no question at all about it. As Spencer has said, what I'd like to do today is to discuss a topic that is right at the top of our agenda at the Commission, which is privacy, and more specifically about do not track. You've probably read our chairman's remarks about do not track recently, and I will warn you ahead of time that this is one of the areas where I have my own views, and I'll be speaking for myself and not for him or for any other commissioner, and certainly not for the Commission. It's been a controversial topic of late, garnering attention not only from the Commission, but also from the media, from Congress, from the online industry, and a host of consumer groups. Congress has proposed several pieces of legislation that relate to the concept of do not track, and the online industry, including trade associations, has pursued divergent efforts at self-regulation. At the same time, some consumer groups have complained that those efforts don't go far enough, while others, and I include myself in that group, are concerned that those attempts at protecting consumer privacy may instead thwart innovation and real informed consumer choice. And this noon, I'd like to share some thoughts regarding those developments. Because I've already spoken and written about my reservations about the general concept of do not track, I won't discuss them in depth here today. But to set the stage for today's remarks, let me highlight a couple of distinctions that I draw when examining issues relating to consumer privacy. First, as a threshold matter, I see a distinction between the issues associated with data collection, that is to say, such as the types of information collected, the means through which it is collected, whether and with whom it is shared, and how long it's retained, as compared to the issues associated with data security, which I consider to be the obligation to keep secure information that's been collected from consumers already. Practices that threaten data security are frequently pernicious, and the Commission has successfully challenged them. I should note at this point that in large measure, my remarks will be recorded on the FTC's website, so you don't have to take notes with respect to them. And I should also disclose that until recently, I didn't really fully understand what Congress is up to, so you're as much in the dark as I am in that regard. Second, I draw a distinction between sensitive information and non-sensitive consumer information. I think we all recognize that certain information should be deemed sensitive, whether it be your personal health and medical records, your personal financial records, personally identifiable information collected from children, and other highly personal information about individuals, such as their sexual preference. Consumer harm certainly occurs when that kind of information is not treated with the proper deference. Indeed, federal statutes such as the HIPAA Act, Graham-Leach-Bliley, the Fair Credit Reporting Act, and Children's Online Privacy Protection Act, otherwise known as COPPA, recognize that and regulate certain aspects of the collection, sharing, and retention of most of that sensitive information. Sensitive consumer information, I think, should be treated differently from other types of consumer information. For example, I think for purposes of behavioral tracking and advertising, sensitive personal information like medical and records, financial data, information collected from children, and other highly personal information should only be collected from consumers after they've explicitly given their permission for its collection and use. In other words, the collection, use, and sharing of sensitive information should occur, in my judgment, only after consumers have opted in to those practices. On the other hand, there's some consumer information, such as consumer preferences, browsing history, information that's not personally identifiable, demographic and age information that I don't think necessarily deserves the same kind of protection. The collection, use, sharing, and retention of those more benign kinds of information arguably don't lead to the types of consumer injury that is associated with the collection, use, sharing, and retention of sensitive information. And as I've mentioned before, the collection and use of that type of data can help fuel innovation, underwrite the costs of providing free content to users, and streamline the user's experience on the internet. And I don't think we ought to be stifling it. Now let me track first the Commission's efforts. As many of you are aware, the Commission officially entered the do not track fray when it issued a 2010 preliminary staff report entitled Protecting Consumer Privacy in an Era of Rapid Change, a proposed framework for business and policymakers, which recommended, among other things, implementation of a do not track mechanism so consumers could choose whether to allow the tracking of certain data, such as their online searching and browsing activities, in order to serve them targeted advertising. And that's, in my judgment, what it's all about, is advertising. That recommendation, however, the staff's recommendation, was not a unanimous one at the Commission. And both former Commissioner Bill Kovacic and I expressed our serious reservations about the do not track course of action. But we agreed with the Commission's decision to issue the staff's report in order to continue the dialogue on consumer privacy issues and to solicit comment on a proposed new framework for how companies should protect consumers' data and privacy. That dialogue has continued. The Commission has testified before Congress several times on issues related to privacy and the concept of do not track. And some of the members of the Commission, including myself, have given speeches and public statements expressing their views on the topic. Also, I imagine that the general concept of do not track will be discussed in any future reports issued by the staff on the proposed privacy framework. While the Commission's work on this issue appears to have been limited to thinking deep thoughts, if you will, namely identifying the possible benefits and downsides of implementing potential do not track mechanisms, there's one notable exception. In a recent notice of proposed rulemaking for the COPPA rule, for example, the Commission recently proposed amending the definition of personal information to add other identifiers that link a child's activities across different sites or services. The effect of the amendment would be to require parental notification and consent prior to the collection and use of persistent identifiers for purposes such as behaviorally targeting advertising to a child. Effectively, that would require parents to opt in to tracking on behalf of their children. And I supported that recommendation because I feel very strongly about children and their welfare. But public comment has been requested on the proposal, as well as a variety of other amendments to the COPPA rule, and I urge you, if you're interested, to submit comments to the Commission staff with respect to those amendments. At the same time the FTC has been analyzing those issues, Congress and the online industry have been actively attempting to implement, to varying degrees, the new do not track concept. Now, I'd like to review the bidding, but let me make it clear again that I didn't understand this congressional action in large measure before I prepared for this speech. You learn something every time when you start looking at speaking about it. So don't take my word as gospel, but this is my understanding of what this congressional action is all about. Congress has tried to address the do not track concept through proposed legislation in two ways. First, by directly instructing the FTC to develop a specific do not track mechanism. And second, by indirectly, through broader privacy bills that consider do not track concerns, addressing those concerns. Two recent proposals specifically take do not track head on, directing the FTC to develop a do not track mechanism. In February, Representative Jackie Speer, actually it is, a Democrat from California, introduced the Do Not Track Me Online Act. And that would require the FTC to issue rules, first of all, establishing standards for an online opt-out mechanism. Second, requiring mandatory disclosures regarding the collection, use, and sharing of certain information. And third, allowing consumers to otherwise, even if the FTC's rule was outside, the tracking was outside the ambit of the FTC rule, otherwise prohibit the collection or use of a broad array of information transmitted online, including online browsing activity, unique identifiers, and personal information such as name, postal address, email address, telephone number, government-issued identification number, or financial accounts and passwords. Frankly, I would consider that to be personal identifiable information or sensitive information, which, as I say, you can prohibit the collection of regardless of whether or not the FTC has prohibited it. Senator Jay Rockefeller, who is a Democrat from West Virginia in the Senate, introduced the Do Not Track Online Act of 2011 in May. And again, it takes the privacy issue on head on. It would require the FTC to issue rules establishing a mechanism whereby consumers can simply and easily opt out of having their personal information collected online, including on mobile devices, and prohibiting the collection of personal information from consumers who have opted out. The Senate bill does not define personal information, but again, I assume that by and large, it's personally identifiable or sensitive information. Now, 3 additional bills address broader privacy concerns, but ultimately reach similar issues regarding the collection and use of online consumer information, albeit without providing for a specific do not track mechanism, whether by FTC rule or otherwise. Representative Bobby Rosch, a Democrat from Illinois, has introduced the Best Practices Act in February to provide baseline privacy standards for collecting and sharing personal information on the internet. In particular, that House bill would require companies collecting personal information to provide, first, clear and prominent notice identifying who is collecting the information and how it will be used, and second, a mechanism for consumers to opt out of having any of their covered information collected. The covered information is a defined term, incidentally, in that bill, which I think pretty much is confined to personally identifiable or sensitive information. The Rush bill would require express opt-in consent for disclosing information to a third party, except for certain joint marketing or service providers who are contractually bound to protect that information, collecting, using, or disclosing sensitive information, so I may be wrong in my reading of the bill, monitoring all or substantially all internet browsing activity, and finally, to prohibiting any material change to privacy practices regarding previously personal information or sensitive information. That's what you've read about recently in connection with Facebook, and the Commission will be taking that issue up in the next couple weeks. But I should add that it's also an issue that was involved in the Google controversy that predated Facebook, and I dissented from that because I thought Google was trying to position us as with respect to Facebook, but who knows? I lost on that one. In any event, there's no question that, in my mind, that when changes are made to previous promises or commitments with respect to privacy by a person making those, or a firm making those promises or commitments, there needs to be some mechanism for disclosure down the line. Senators John Kerry and John McCain, and you know them, introduced the Commercial Privacy Bill of Rights Act of 2011 in April. That Senate bill would require the FTC to issue rules requiring companies that collect personal information to, first of all, provide notice of their collection and use practices. That's what triggers the obligation of deception in most of these cases. And second, to provide an opt-out mechanism when using personal information in an unauthorized manner. And the Kerry-McCain bill would require an opt-in mechanism for collecting, using, or sharing of sensitive information, which I think is appropriate, or the use or sharing with third parties of previously collected personal information whether it's sensitive or not, after a material change to the privacy practices and where the use or sharing creates a risk of economic or physical harm. Frankly, where it satisfies the latter criterion as well, that is to say, it creates a risk of economic or physical harm, I don't have any problem with an opt-in requirement either. The day after the introduction of the Kerry-McCain bill in the Senate, Representatives Cliff Stearns, who's a Republican from Florida, and Jim Matheson, who's a Democrat from Utah, in the House, introduced the Privacy Protection Act of 2011. Now, that bill would require that before collecting any personal information from a consumer, a firm must provide, first of all, notice regarding how the information will be collected and used, and an opportunity to opt out of the sale or disclosure of that information. That opt-out privilege, however, would not be required if the information is being transferred to an information sharing affiliate, defined as an affiliate that is either under common control of the covered entity or is contractually obligated to comply with that entity's privacy policy. But unlike the Rosch and Kerry-McCain bills, there are no circumstances for which the Stearns-Matheson bill would require opt-in consent. Now, in addition to the transparency and opportunities for consumers to control aspects of the collection and use of their personal or sensitive information, those bills have a number of things in common. First, some of the bills acknowledge the distinction that I draw between data collection and data security. For example, although the primary focus of the broad privacy bills consider the collection and sharing of consumer information, both the Kerry-McCain and the Rosch bills each specifically require data security safeguards for collected data and obligations to retain personal or sensitive consumer information only so long as necessary to fulfill a legitimate business purpose or to comply with a legal requirement. Although less detailed, the Stearns-Matheson bill similarly requires an information security policy that is designed to prevent unauthorized disclosures or release of personally identifiable information. So that bill also has a mechanism for absolutely protecting, on an opt-in basis, some kinds of information that I would consider to be security information in nature. Second, the bills make distinctions, again, as I've suggested that I do as well, between sensitive personal information on the one hand and other information on the other. Indeed, presumably consistent with consumer expectations, all of the legislative proposals generally provide exceptions for first-party information collection related to the transaction or service. Similarly, some of the bills propose to exclude aggregated or anonymized information. The Rosch and Kerry-McCain bills, however, draw the distinction that I've mentioned between sensitive and non-sensitive information and require express opt-in consent regarding the collection, use, sharing of sensitive information such as a person's medical records, of religious affiliation, or information that, if disclosed, poses a significant risk of economic or physical harm. Third, the majority of legislative proposals incorporate some manner of self-regulation. The Rosch, Kerry McCain, and Stearns privacy bills all propose participation in approved and monitored self-regulation programs as a safe harbor from the regulation. For example, the Rosch bill would provide a safe harbor that would exempt companies from certain opt-in consent requirements, provided those companies participate in a universal opt-out program operated by self-regulatory bodies approved and monitored by the FTC. Similarly, although neither the Spear nor the Rockefeller bills proposes self-regulation, the Rockefeller bill directs the Commission in designing the standards and rules for the implementation of an opt-out mechanism to take into consideration the mechanisms that have been proposed by the industry thus far. So now let me turn to the online industry's implementation of Do Not Track. As things now stand, there's a handful of different mechanisms that purport to give consumers the choice to eliminate behavioral advertising, and some that purport to eliminate both the tracking and targeting of advertising. The most prominent options developed to date are browser-related mechanisms associated with Microsoft's Internet Explorer 9, Mozilla's Firefox, and Google's Chrome. I should add that I deliberately omitted Apple, which has a do not track mechanism as well that is associated with its browser, but I do not cover it. And the self-regulatory regime set up by the DAA, or Digital Advertising Alliance. I want to discuss each of those in turn, and I'm going to be critical about them. I should warn you in turn. Microsoft's Internet Explorer 9 offers a do not track mechanism that uses third-party domain blocking to prevent certain third-party websites from establishing contact or accessing the consumer's computer. That opt-out mechanism involves the use of whitelists or blacklists known as tracking protection lists, or TPLs. Those allow consumers to decide which third-party websites they will allow to access and therefore potentially track their online activity. In order to opt in, the user goes to the browser's safety settings, where there's an option to create a personalized TPL based on script and tracking cookie information from previously visited websites, or to subscribe to one of 5 already created TPLs. Although consumers are given the choice to create their own TPL, it may be hard for them to do so in an informed fashion because they don't have access to complete details about the information collection, use, and sharing practices of the websites they may or may not want to block. The already created TPLs are furnished in turn by self-interested parties, such as consumer advocacy groups or industry trade associations, who have their own views on whether and to what extent consumers should allow tracking of their non-sensitive information. But there's no indication that consumers agree with the views of those self-interested parties. Furthermore, the user doesn't know which sites are on the already created TPLs until after they have used them. Only after the user selects and downloads a particular TPL can they see which sites have been blacklisted or whitelisted. So in other words, that tracking mechanism is based on whitelists or blacklists that are provided by self-interested parties, which may or may not track what consumers want blacklisted or whitelisted. Now, Mozilla offers another browser-based approach to do not track in its latest version of Firefox. That mechanism, if enabled, sends an HTTP do not track header. You're familiar, if you're a computer user, with headers, along with the user's request to access a website. The website receives the do not track request and is supposed to honor it. And if it's a respectable website, I think it probably will honor it. And although that approach does not interfere with the functionality of websites or their content, the mechanism is nevertheless basically unenforceable, except through reputational constraints of the website. It relies entirely on the good faith of the recipient third party to honor the do not track mechanism. Furthermore, the mechanism activated by a single click in the Tell Websites I Do Not Want to Be Tracked box of the advanced settings does not fully inform users of the consequences of their choice, both pro and con. Now, recently, Mozilla released a field guide which purports to inform consumers of the types of tracking that are occurring and of the consequences, various consequences, of opting out. But any usefulness of those disclosures is undercut, in my view, by the fact that they are not proximate to the choice mechanism. In addition, it's not clear how complete or accurate are the descriptions of the tracking that's now occurring or the consequences of opting out. Finally, despite arguably being the simplest do not track mechanism to enable, only 5% of Firefox 4 users have enabled that feature to date. And that rate of implementation by users makes me wonder whether or not consumers are actually aware of the existence of that do not track mechanism, or alternatively, how consumers are actually concerned, how many consumers are actually concerned about being tracked. The third browser do not track mechanism is offered by Google, which has a plug-in called Keep My Opt-outs that can be downloaded to the Chrome browser. As you may know, the Chrome browser is not the most popular browser in the world today. In fact, I think it's probably third. But it nevertheless has an opt-out mechanism. Now, Keep My Opt-outs, that download, purports to allow a user to permanently opt out of ad tracking from all companies that offer opt-outs through the industry self-regulatory programs and offers automatic updates to include new companies as they continue to join self-regulatory networks. Notice I use the term purports advisedly, as I'll get to in a moment. As such, though, on its face, this plug-in feature comes to grips with two major problems faced by some other do-not-track mechanisms. The impermanence of opt-out cookie-based solutions, which disappear when the consumer clears his or her cookies, and the need to stay up to date with new ad platforms as they join the self-regulatory programs. The web page containing the download for the plugin mentions some of the negative aspects, consequences of installation. The ads the consumer sees may be less relevant to that consumer's choice and diverse, and it may also result in less profitable ads for the consumer's favorite websites. But the mechanism offered by Google appears to only limit the consumer from receiving targeted advertising. That's why I used the word purports. Keep My Opt-outs does not stop websites from otherwise tracking a consumer's online activity, and cookies continue to be installed on the consumer's computer. In addition, since the plug-in only prevents ad tracking and serving by companies that are members of self-regulatory programs, such as DAA, the scope of the mechanism is limited. Consumers would still be tracked and served advertising by any companies that are not members of a self-regulatory program. The final mechanism uses cookies to effectuate the choice mechanism. The DAA, the self-regulatory body comprised of the nation's largest media and marketing associations, launched its self-regulatory program for online behavioral advertising in 2010. And since I'm an equal opportunity basher, I'm going to bash DAA along with these other mechanisms. The DAA program requires that member companies engaged in online behavioral tracking or advertising provide enhanced notice, and I'm quoting DAA now, to consumers about collection and use practices, and offer a choice mechanism with respect to the collection and use of data for online behavioral advertising purposes. For most program participants, that enhanced notice involves the use of an icon that's located near or on the advertisement itself, and that takes users to a page containing the required disclosures and an opt-out mechanism. The disclosure requirement, however, could use improvement in several respects. First, some have suggested that the icon may not be prominent enough to actually prompt consumers to click on it for the required disclosures and the instructions on opting out. Second, assuming, however, that a consumer finds the icon and clicks on it, the presentation and organization of the disclosures that appear vary depending upon the entity that's serving the icon. And there are three of those entities: Evidon, Trustee, and Double Verify. While users are eventually informed about the consequences of adopting the mechanism, in particular the loss of advertising relevance and the effect on the economics of advertising on the internet, It takes some perseverance and more than 1 or 2 clicks to reach that kind of pertinent information. And finally, and perhaps most importantly, the choice mechanism for DIA is merely an ad preference manager dressed as a do not track mechanism. For the most part, it allows consumers to manage their behavioral advertising interest categories or to opt out of receiving targeted advertising. It does not, however, stop data collection or the placement of cookies on consumers' computers. There appear to me to be at least 4 overarching shortcomings with the current industry or self-regulatory do not track mechanisms that I've mentioned so far. The first is that some of the mechanisms only allow consumers the ability to opt out of behavioral advertising, but not all behavioral tracking. And there's a failure to alert consumers to that fact. A recent study conducted by Stanford researchers indicates that there's consumer confusion on that issue, and that consumers, perhaps because of the moniker do not track, think that they're opting out of being tracked, not just opting out of receiving targeted advertising. Both the Google Keep My Opt-outs and the DAA self-regulatory program suffer from that shortcoming, and neither one adequately informs the consumer of the limited scope of the opt-out. Second, with regard to some of the do not track mechanisms, although their disclosures may be sufficient to warn consumers that one of the consequences of opting out will be that the consumer will lose access to relevant targeted advertising, most of the notices do not warn of the other possible consequences of opting out. For example, I remain concerned that consumers are not being informed about the across-the-board consequences of opting out, namely that they may reduce the overall financing that supports free content across the internet and accordingly results in a decrease in innovation. There's limited disclosure on that point. For example, only one program, the Google plugin, alerts consumers that engaging the mechanism might result in less profitable advertising for their favorite websites. The DAA program explains how internet advertising funds free content, but that information is not presented clearly and prominently, and certainly not with respect to an across-the-board loss of free content. And none of the mechanisms specifically alert consumers that the result of selecting a do not track mechanism may also result in more obtrusive advertising, although maybe that fact may be surmised by the notice that they'll receive less relevant advertising. The third shortcoming is that the proof of the pudding is in the eating. I don't see much evidence that those mechanisms are really working to alert consumers about the existence of tracking and online behavioral advertising. For example, the rates of adoption are very low. As I mentioned earlier, only 5% of Firefox users have enabled the Firefox feature. With respect to the DAA program, a recently published press release stated that more than, and I'll quote, 80 million US internet users were served ads with the ad choices icon, and that, quote, the 50 billionth impression of the advertising choices icon was served on behalf of the licensees of the DAA. Those numbers just represent ads that consumers may or may not want to see. The press report provides no indication as to whether consumers are clicking through on the icon, as I would put it, to get more information, and actually notes that, and I'll quote, even as the program's growth and number of companies have accelerated, the opt-out rate on impressions served remains extremely low, end quote. A corollary to that is the question whether the DAA opt-out mechanism actually functions in the way that DAA members represent that it will. There's been a recent study conducted at Carnegie Mellon suggesting, again, with respect to the DAA self-regulatory program, that the program doesn't always function as represented. The fourth shortcoming may be more serious and incurable. The current proposals all involve, to some degree, well-entrenched firms, whether as implementers or participants. Those firms may favor barriers to entry to consumer tracking. That is to say, they may hike up the bar in order to create or raise entry barriers to rivals, instead of being designed to promote the protection of consumers against behavioral tracking. Let me set the table a bit. Some of the participating firms offer advertising that's not display advertising, which arguably is heavily dependent on behavioral tracking. Beyond that, some of those firms offer their advertising through vehicles that are not as accessible to rivals offering display advertising. Those firms may be tempted to sail under the consumer protection banner when their predominant interest is instead to disadvantage rivals that are more heavily dependent on advertising reliant on behavioral advertising. That's something we've worried about at the FTC since the dawn of self-regulatory mechanisms. Former Commissioner Kovacic has remarked that we're a better antitrust agency for having a consumer protection mission, and that's surely true to a point. But we can't be blinded so much by our zeal to protect consumers that we lose sight of behavioral tracking that may be instead designed to frustrate rivals. There's probably nothing worse than to have firms with an anti-competitive agenda designing consumer protection initiatives. So where does that leave us? From what I've seen thus far, do not track is clearly a very hard technical issue, both as a matter of definition and implementation, without a perfect or even a pragmatic solution. In short, I have reservations whether any of the self-regulatory programs, including the DAA program, really do present consumers with a mechanism that will both fully inform them before they make a choice about whether to allow tracking of their non-sensitive information or not, and whether they can and will really exercise that choice. I'd suggest that the jury is still out on those questions. Accordingly, I would suggest further that it would be premature for us at the FTC to put all of our eggs in the self-regulatory basket, either as part of an industry solution or as part of a legislative solution, as I've indicated, 3 bills before that the Congress is considering currently do, to resolve the do not track question. And now I'll be glad to take any questions you may have. I know this was pretty heavy lifting.
Commissioner Rosch, David Wolanski. One question about the Mozilla solution was you mentioned that they have a directory where they could track some of the kind of bad actors who didn't comply. Could that Mozilla solution be, could a loop be completed if they actually took that directory and implemented that on the website to prevent consumers from surfing on those sites or warning consumers when they were to surf on those sites?
I think there are 2 problems with the Mozilla solution, one of which is maybe curable, although frankly I'm not sure that it is, and that is that it's basically unenforceable. As I indicated, that is not to say that it is completely unenforceable, because I think if a reputable website deploys that solution, it's likely that third parties will agree not to track. But that said, the third party has to agree as well not to track. And there is currently not in place any kind of enforcement mechanism. The second problem that I see with it, quite frankly, is that it does not inform consumers fully of the consequences of opting into a do not track mechanism, particularly as it relates to both the pro and the con consequences. I've been a big advocate of full disclosure up front with respect to the consequences, because I think fully informed consumer choice is the way to go. But that means telling consumers how ubiquitous is the tracking of their information through the sale of their information to third parties, and we don't know. We have no idea. The surveys that are out there right now are framed in such a way that they assume the answer. So I don't put much stock in the surveys that are out there right now. Secondly, they don't tell what the pro consequences, or I'm sorry, the con consequences of selecting a do not track mechanism may be. As for example, I do think that they do a reasonably good job, although Mozilla does not, of suggesting that you're likely to be served less relevant advertising. And you're likely to be served advertising which in the aggregate is less likely to be able to support free content. And they certainly, as I indicated, none of them suggest that by selecting this advertising or the do not track mechanism, you're going to be inviting really more obtrusive advertising into your home, which may be the case. There have been some studies done that suggest that that's so.
Well, Commissioner Rafael Rivera, I just had an observation I was hoping that you'd be able to remark on. Given the economic and technical characteristics underlying these dynamic innovation markets, many times dominance is a fleeting phenomenon. You know, this in turn suggests that competitive forces are apt to facilitate pro-consumer services. And that is, you know, if consumers are really concerned with privacy rights and hence there's a market for these services, entry is likely to occur and capture that demand. The fact that it hasn't, or that no rival has leapfrogged, you know, current services like Facebook or Google, would suggest that, at least I think, consumers are okay with this trade-off. So I'm not sure that there really is, I guess, a market failure of warranty and regulation?
You know something? I got to tell you, Raphael, as somebody who represented large, well-entrenched organizations, business organizations, my entire practice career for over 40 years, I'm suspicious of Chicago school neoclassical economics. That's not to say that they don't have their place. I think they do. But I think they go way too far in proposing that markets will cure all and that there's frictionless entry into markets. I just don't think that that's the case. And the recent behavioral economics literature would suggest that it's not so. So that's all I can tell you. I come with it with my own biases. There's no question about that.
Just to follow up on that, has the FTC engaged in, or I guess conducted any empirical analysis as to whether consumers would be, for example, willing to pay subscription fees for services that they are receiving now for free?
The answer is no. We have not. I will say this, and I think I'm not letting the cat out of the bag in this regard. We have certainly examined the question as to whether or not consumers ought to pay for search capabilities that they're now getting for free. And we've concluded that consumers wouldn't like that. Yes.
Commissioner Ted Banks.
Hi, Ted.
Have you or has the staff consulted with any of the other countries that have addressed this issue, particularly in Europe where privacy is a much different animal in the United States, where they're actually requiring affirmative opt-ins before anything can happen?
Only in the most oblique ways. I was at a conference, for example, in Berlin last year, where I objected strenuously to a gentleman from Germany as suggesting that we had no privacy rights whatever in the United States. I reminded him that certainly we had privacy rights. We have a whole law that deals with illegal search and seizures. We have a whole law that deals with wiretapping. But that said, I think that we have to remember that Europe has a different history and culture than we have. And we're probably never going to be able to snuggle up to them with respect to privacy. Until 9/11 at least, and arguably since 9/11, we haven't experienced the kind of intrusive behavior that those regimes that, or those people that experienced the state intruding into their lives through Nazism or communism in Europe have experienced. Now, that's not to say that we're perfect, because we aren't. And I was reminded by a lady from Canada the other day that Canada doesn't have that kind of history or culture either, and yet they take a different view about privacy than we do. But for the reasons I've suggested, I am skeptical about our ability, just putting to one side philosophical differences, about our ability to really implement or deploy a viable do not track system. Okay, Spencer, take it back.
Please join me in thanking Commissioner Rosch. Thank you all for being here.